Madam, under the Legal Profession Act, an applicant cannot be admitted as an advocate or solicitor if he or she is not of good character. When applying for admission, the applicant has to affirm or swear by way of affidavit facts that affect his suitability to practice as an advocate and solicitor. This includes any misconduct or ethical breaches. Additionally, the applicant must also exhibit in his affidavit a certificate of diligence from a Singapore law practice from which he received supervised training. The Singapore law practice cannot issue this certificate of diligence if it knows of any misconduct or ethical breaches that affect the applicant's suitability for admission as an advocate and solicitor. The admission criteria do not distinguish between misconduct or ethical breaches which take place during or outside the course of an applicant's undergraduate law studies. The affidavit which the applicant affirms or swears by must be served on the Attorney General, the Law Society, and the Singapore Institute of Legal Education. They may file a notice of objection against the applicant should they determine that he is not of good character. Similarly, members of the public, including law schools, who may have knowledge of facts that have a bearing on the applicant's unsuitability to practice, may also file a notice of objection within 30 days of the application for admission. The agencies concerned do not keep records on the number of persons who will refuse admission to the bar on account of previous misconduct or ethical breaches.
Affirming that ethical breaches, even during the course of studies, could impact upon one's suitability for admission to the bar. My question here is whether the law schools are sufficiently appraised of this. I know it might come as a surprise, but never in my career as a law academic, have I known of academics being approached by the law school, to indicate whether students should be, such cases should be notified to the relevant agencies. And when you ask the students also take the same view. They do not see their conduct or misconduct in the law school as having any bearing with their suitability for practice. So I appreciate the affirmation, but I think there's a need to emphasize this, and of course the question is, which is the relevant body. But I think it's important because students think they can get away, and I think many of the bad habits are actually learned during the course of their undergraduate studies. Thank you.
Madam, I thank the member for his comments. Indeed, in order to become an advocate and solicitor and called to the bar, it is important that the applicant is of good character and the right suitability. And good character and right suitability does not start from the time you begin your training at a law practice. It is something which pertains to the essential individual character of that person, and it could be something which has occurred even before the applicant has made the application to be admitted to the bar. So that is the first point, that this issue of character is not constrained in terms of time. But what is important is at the time that the application is made and heard, the court has the opportunity to determine that the person is of the appropriate suitability to be admitted. Because after all, that person is going to have in his or her hands the practice of the law that affects the rights of individuals and the public at large. That's the first point. The second point that the member made was whether or not the law schools were aware of their ability to communicate their knowledge of any misconduct or ethical breaches. The members of the law school would also be lawyers, and they should be acquainted with the law. In case they are not, I would direct their attention to Rule 28.1 of the Legal Profession Admission Rules. And these are the rules which say that any member of the public may file a notice of objection. And indeed, that is the purpose when you put in an application to court. The fact of the application is made public. It is put on the court website. And the purpose of that is to give notice to everybody that this particular person has applied to be admitted to the bar. And by the same token, anybody who has an objection can put in a notice of objection. So certainly, whilst this can be promulgated publicly, I would urge the law schools to look at the rules, and also in the course of their disciplines for the students to encourage the students to remember that this issue of character spans not just the time they make the application, but before then and even after they're called to the bar.